Hi, everyone. Thanks for tuning into my short webinar, Understanding Estate Planning. My name is Jim Kipp. I'm the owner and president of Kipp Wealth Management. You know, for most people, estate planning isn't even on their radar. Most people don't know if they should have a will or if they should have a trust. They know they should have something, but they're not quite sure which one is better for them. Over the next 20 minutes, I hope I can clear up the confusion and give you some insights into why it's so important for you to have an estate plan. Again, my name is Jim Kipp. My company is Kipp Wealth Management. I've been in practice for over 40 years now. I'm a financial strategist. I specialize in retirement planning, estate planning, legacy planning, and asset protection. I'm located in Palm Coast, Florida. About 12 years ago, my wife and I moved from Wisconsin to Florida, and I do business all over the country virtually. This is my back office support. I've got a number of people working for me. They help me with reports and research and putting together cases for my clients. But first, let's have a disclosure here. The legal documents that we provide are written by attorneys, provided with estate document software. We can provide you with estate document software that's licensed from Estate Documents Pro LLC. This presentation provides general information about legal topics. Kipp Wealth Management LLC, KeyEstateDocs.com, Legend Partners LLC, and Estate Documents Pro LLC are not law firms and do not provide legal or tax advice. This presentation and any products discussed are not a substitute for the advice of an attorney. You should consult with an attorney and tax advisor licensed to practice in your state for advice if you have any questions about your specific circumstances. So when should you start an estate plan? Some things you want to consider whether you're young or old. What if you become incapacitated? Who's going to take care of you the way you'd like to be taken care of? Who can legally take care of your finances for you? What if you have minor children? Who's going to take care of them if you're not around or if you're no longer capable of making decisions? What if you have a family member with special needs or a drug problem? Is it a good idea for them to inherit a lump sum of money? You know, over 50% of Americans do not have an estate plan. The people who do only have a will, mistakenly thinking their families won't have to go through probate court. Estate planning is essential if you own a business or an LLC or any real estate. If you own property in more than one state, you have minor children or children with special needs, you have children from a previous marriage, your spouse or family members aren't comfortable handling financial matters, you want to make significant charitable gifts, you have estate tax concerns, you want to avoid assets being tied up in the courts, you want to keep a total control of your estate, and if you become incapacitated, your treatment is carried out according to your wishes. And if you want to protect your estate from Medicaid. So these are all things that you need an estate plan for if you want to take care of this. So which plan do you have? Do you have the government's plan or do you have your family's estate plan? If you don't have an estate plan, your family automatically gets the government plan. The question is, which plan gives you and your family the control over your estate? If you don't have a will, or even if you do have a will, your family must go through probate. The probate process is slower, more expensive, and your information will be made public. Most people are unaware of how simple and easy it is to put a personal estate plan in place that gives them the control over their legacy. The probate Court process, the court decides who receives your assets and how. Your family's privacy is lost. That exposes your whole estate and all your assets to identity theft. Family waits months or even years before receiving assets. Probate fees range from 3 to 10% of your total estate. So if your estate is worth $1 million, you're looking at a cost of about $300,000, or maybe $100,000 or $30,000, or maybe $100,000. The executor of your will, whoever you make as your personal representative, these are the duties that they have to do. Upon your death, all your assets are immediately frozen. Your personal representative must file petition for probate. They must catalog all property of the decedent, including real estate and personal property. They must get appraisals on all real estate and anything else that has perceived value. All the values can be questioned by the courts. They must pay any outstanding debts, claims, or taxes that are due. They must collect any income due, like royalties or stock dividends, to which the deceased was entitled. They must settle all financial and property disputes, such as liens. Must file the decedent's final income tax return. They must file an estate tax return if needed. They must prepare an accounting of all estate assets and all expenses. They must litigate any creditor claims. They must distribute or transfer the remaining property to the heirs. If the personal representative lives out of state, then the executor bond may be required. The cost of the bond depends on the value of the estate and the personal representative's credit score. So this is a real problem. If you have certain family members, normally, you're probably going to name one of the kids, adult kids, as a personal representative, and you have to make sure that they're willing to do all of this stuff on their own. Is a last will and testament enough? Well, it's much better than having nothing, but it's basically a wish document that still passes through probate. And the consequences of not having an estate plan, if you have minor children, if you don't have a will, the courts will be tasked with appointing a guardian for your children. The process can be lengthy, emotionally taxing, expensive, and stressful for the children and family members. A judge will decide who manages your children's financial assets, potentially taking months or even years. The person who is ultimately appointed by the court as guardian may not align with your wishes. Family members may disagree, causing family conflicts and disputes. Children's assets will be locked up to age 18, then distributed in a lump sum. If there are children from a previous marriage, an ex-spouse could end up with some of your assets. Good example is if you have a 529 plan for your kid's college education, well, guess what? That's your child's asset. It's not your asset. So that asset would go along with them after your death, and maybe an ex-spouse could have access to that money. Durable power of attorney over finances. It's a legal document that allows another person to transact personal financial business on your behalf. Most common need is if you would become incapacitated. Someone you trust can make sure your finances are maintained when you are unable to maintain them yourself. Not having this document could mean your family may be forced to petition a court to be appointed as your legal guardian to take care of you. It's strongly recommended that you keep this document up to date. Durable power of attorney over healthcare. Durable means that the POA, or power of attorney, remains in effect even if the principal becomes mentally or physically incapacitated. The agent's role is to make medical decisions such as consenting to or refusing treatment based on the principal's wishes and best interests. These decisions might include life-sustaining treatments, surgeries, medications, and other healthcare related matters. The principal can specify in the document the scope of the agent's authority, including any limitations or preferences regarding certain types of care, such as end-of-life decisions. The principal can revoke or modify the durable power of attorney for healthcare at any time while they are still mentally competent. The principal can choose anyone they trust to be their healthcare agent, such as a family member, a friend, or a professional like a financial advisor or attorney or a banker. Living will and advance directives. An advance directive, or which is called a living will, gives you a way to express your values and desires related to end-of-life care. You might think of it as a living document, one that you can adjust as your situation changes because of new information or a change in your health. So if you're over 55 years old, you probably remember the Terri Schiavo case. It's the most recognized case of not having a living will. In 1990, when Terri was 26 years old, she suffered a cardiac arrest. Terri developed brain damage from lack of oxygen. She became comatose and was in a vegetated state. Because Terri had no advanced healthcare directives, she was put on a feeding tube. Terri's husband went to court and was granted the right to be her legal guardian. In 1998, her husband had Terri's feeding tube removed because he didn't want her living like this anymore. Her parents filed a suit, and a judge determined that Terri would have wanted to continue life-prolonging measures. The feeding tube was removed, but was reinstated a few days later by order of another judge. In March of 2005, a judge ordered Terri's feeding tube to be removed again, and she died 3 years later. Over a 15-year period, there were 14 court appeals, petitions, and hearings. They were fought in the Florida State Court and the Federal Supreme Court. The United States Congress got involved as well as Governor Jeb Bush and President George Bush at that time. This all could have been avoided with one estate document, a living will. Over 75% of the estates in America will be subject to probate court. So why don't people take the time to set up an estate plan? Well, they think it's only for old people. They think only for people after they die. They don't have many assets. They think they don't have many assets, so they don't need a plan. It's an intimidating process. There's attorney fees and it's too expensive. It's an uncomfortable topic for them and their family members. And they think it's too complicated and they end up procrastinating. They think, well, I've got plenty of time to do this later. Revocable living trust. It's a separate legal entity you create to place your assets in while you're alive. You can move the assets in and out of the trust at any time. It's very flexible. You maintain complete control over your assets. It allows you to decide who gets your assets, when, and how they receive them. Since your assets are in a separate entity, there is no probate required. A trust is like a basket where you put some of your assets and carry it with you while you're alive. At your death, your successor trustee can easily and privately pick up the basket and follow your instructions for management and distribution. This keeps the court system out of your family's estate, and it keeps your family in total control of your estate. Funding your revocable living trust. 80% of revocable living trusts are not funded or are not funded correctly. Most law firms only provide you with instructions about funding your trust, It's up to you to fund it. You have no idea how many trusts I look at, and the people didn't even fund the trust. It was just sitting there doing nothing, and they paid all this money for that. If certain types of assets are left outside of the trust, your family could be headed to probate. So it doesn't take much. If there's assets that are not set up properly with your estate plan, the family is going to go to probate anyway. If certain trusts, certain types of assets are put into your trust, it could cause tax problems, or you could lose benefits. So it's very important that your trust is set up properly according to your situation. It's essential that you know which assets to include into your trust and which assets you shouldn't. As an example, should you put your retirement plan into your trust? Well, 99.9% of the time, your IRA or 401k should not be put into your trust. And the reason for that is because your trust is not a human being, it's an entity. And when that trust has to pay out that IRA or 401k plan, it's 100% taxable. So it's going to be paid out in a lump sum. So that would be a bad thing. There's other ways to do this properly by letting your family members stretch it out over, let's say, 10 years and pay the tax over 10 years. Should you put your home into your trust? Well, that depends. Depends on your situation. Are you planning on, if you need long-term care, are you planning on going on Medicaid? Or are you planning on being able to pay for long-term care costs down the road? So it depends on the situation, whether or not you put your home in the trust. Now, Medicaid estate recovery means that if you go on Medicaid and you're having the state pay your long-term care costs, well, that means that the state can come and recover those costs after your death. So putting your home in a revocable living trust does not protect it from Medicaid estate recovery after your death. It's fair game for the state to take your home after your death to help recover nursing home costs. So if you think you're passing your home over to your kids after your death and you're on Medicaid, the state can come up after that house to recover costs. So let's just do a sidebar here real quick. Protecting your estate from long-term care costs. Well, the risk is real. Every 68 seconds, someone is diagnosed with Alzheimer's. Every 40 seconds, someone has a stroke in the United States. 70% of Americans over age 65 will require some type of long-term care. The average life expectancy is 84 to 86, so you need to prepare for longevity in your estate plan. Here are some costs if you don't know it, if you don't know this already. The average stay in a nursing home is 3 years, and the average cost is about $10,000 a month, so $120,000 a year. Times 3 years, that's $360,000. In-home care, the average stay is 4 years at $57,000 a year. So the cost could be $228,000. If you want to use assisted living care, the average cost for that is over 8 years of $48,000 a year. So that's $384,000. And the thing with assisted living care is you're probably going to end up in a nursing home after using assisted living care. And so now on top of that, you got to pay for nursing home care. So it gets very, very, very expensive. So the question is, how are you going to pay for those long-term care costs? Would you be able to pull out over $300,000 from your retirement account? And would it be wise for you to do that, since you have to pay 100% of that is taxable on the distribution. So, paying tax on $300,000 at 30% tax rate, you're looking at close to $400,000. Should you plan on going on Medicaid, or would it be wise to make sure your financial plan includes protecting your estate from long-term care costs? Is it smart to self-pay and pay for long-term care costs dollar for dollar? I know quite a few people who are ready to self-pay. They say, they have enough funds to be able to pay for the long-term care costs, but it's dollar for dollar. Does that make sense to do that? Maybe, wouldn't it make more sense to take advantage of a federal tax law that's available for you to set up a private tax qualified long-term care plan and pay only 25 cents on the dollar to get tax-free supplement income that helps you pay for your long-term care costs? In other words, they're waiving the taxes on this, so you use that as a supplemental income on top of the current income you're bringing in right now, and it's only 25 cents on the dollar if you do it that way. That would be a smarter choice. Now, another thing that most people don't know is that Medicaid is not an entitlement, it's just a loan. Adult children now may be held responsible for parents' death after death, for parents' debt after death. 29 states now have a filial responsibility statutes on the book. What that means is that 29 states here listed already will go after the kids' assets to pay them back for their parents' long-term care costs that the state paid. There's quite a few states following suit behind these 29 states. And the reason for that is because Medicaid is in trouble, and the states are looking for ways to pay them back. And the states are in trouble financially. So getting back to the wills and the trusts, KeyEstateDocs.com is a company that I use. And it's a great solution for you. It's the 21st century estate planning document technology. It's basically an online program that we use, and it's very affordable. So instead of going to your local estate planning attorney down the road and paying a huge amount of money for them to set this up, you will go online and I would help you because I'm the estate planner in this case. And all you do is you answer these questions here right in a row. And it's a questionnaire, and it puts the wording is already set up for you based on your situation. And it eliminates many of the traditional costs incurred when working with an attorney, and it's guided through estatedocs.com, and also me. I'm the quarterback in this situation for you. You also have a secure document vault. Everything is encrypted. You have 24/7 access to signed copies of all your documents. This is pretty cool because we just upload everything that you've done, including your signed, the witnesses that signed your documents, and it's notarized, so that all those documents get uploaded. You can always go in there and make any changes for free. And as far as funding your trust, we have a proprietary funding kit. We do what attorneys don't do. We make sure that your trust is properly funded. So by the time you're done with this whole procedure here, the whole process, you're going to get a binder with all your documents in there, and the funding on this is going to be proper, and it's going to be done in the right way. So we're looking at everything from your cash accounts at your savings, your vehicle, the vehicles in your car, We do this step by step, and it's done the right way, all in regard to all of your assets. And you just go down here and you fill in, like for instance, on your vehicles, you just put in the make and model of your car, the VIN number. And the nice thing about this is if you sell the vehicle, well, guess what? You don't have to run to your attorney and spend another $200 for them to make the change. You just do it right inside of your own website. Of course, you'd print out the new document with the new information, and you just get it signed and notarized and put it back into your revocable living trust. So these are all attorney drafted documents through estatedocs.com. And what it includes is a pour over will. So if you're married, you both will still have wills inside of the estate plan. But what that means is that allows that if you have any assets that are outside of the revocable living trust that were supposed to be put in there, the pour over means that upon your death, it automatically pours into your trust for you. Okay, so you're not going to be risking having to go through probate. You get a certificate of trust. That means that you don't have to bring your whole trust over to, let's say, a bank or a brokerage firm or something to prove that you do have a trust. It's just a summary, basically, that they can look at. And you have durable power of attorneys over finance included, durable power of attorney for healthcare. You have your living will, which will be set up, which shows what your advanced medical directives that you request. If you have minor children, you'll have guardianship for minor or adult disabled children. And then in your exclusive funding kit, you're going to have unlimited funding letters that you can use, you can fill out yourself rather than going to an attorney, because these are all legal documents. And it's unlimited. You can make changes anytime you want. You have online document vault to upload your important documents into your trust. Free unlimited changes, free unlimited updates. This is important because let's say, for instance, if you moved out of state, well, you have to redo your trust. I mean, to within the laws of that state. So now you can do this on your own website. We'll have asset protection tips for you for long-term care. And if you already have a trust or a will, it's a free review of that. So, let's get this done. If you don't have something set up currently, let's stop procrastinating and let's get it done right now. A typical comprehensive estate plan, it costs about $5,000. And we're giving a $3,000 discount, limited time on this discount, but we're giving you a $3,000 discount for people that are watching this webinar. So your cost would only be $19.95 for the total package. That's a very, very good deal. And of course, I'm the licensed estate planner, so I would be helping you through the whole process of this. So if this is something that you want to take a serious look at, you can scan the QR code, or you can just go to kipwealthmanagement.com, go to my website. Both of these take you to the website, and then you can look at another video in there, and then you can schedule a free demo and free consultation with me, because it's very important that we have a discussion first before you try to go ahead with this. So I hope you enjoyed the webinar, and I hope you gained some insights. And I certainly hope that we will be talking together soon. So thanks again, and have a great day.